Second Amendment provides that the right of the people to keep and bear arms shall not be infringed, and it has a prefatory clause of well-regulated militia being necessary to the security of the state. So, look at the key terms. The right of the people, keep and bear arms. Arms, hello. Rifles, pistols, shotguns. That's the main arms in our society, but it also include blunt weapons and edged weapons, which are more historical, obviously. So that's the issue. Now, for many years, starting in about the 1960s, you had an invented theory of the Second Amendment that the right of the people to keep and bear arms really meant the power of states to maintain militias like the National Guard, and there was no specific individual who had any right. We challenged that intellectually in law review articles and in books starting in the 70s and 80s, and finally our view became the predominant view in the academic world, with the collective rights of people hanging on to the extent that by the time the Heller case came before the Supreme Court, Justice Stevens argued for an individual right to keep and bear arms in his dissent, but only in the militia service, which was actually a pretty wacky theory. If you have a right of the people to keep and bear arms, it doesn't say limited to the militia, and you don't get to do anything you want to in a militia. It's a military force, so that you have a command society where officer gives orders and you obey it. There's no right to do anything in particular. You don't have a right to free speech or assembly or any of these other things in the military force, including a militia. So around 1989, California passed the first ban on America's favorite rifle, which I will call by AW. And it had a list of evil, wicked, mean, and nasty names and model numbers, manufacturer names and model names or numbers. AR-15, Colt AR-15 leading the list. Aftermath Kalashnikov. They didn't know that Aftermath Kalashnikov really meant a full auto selected fire machine gun. So that was the first ban, and then they started bringing in generic characteristics that I'll talk about a little bit more later, like the horrible, conspicuously protruding pistol grip. I know you're going to be frightened when I use terms like that. Excuse me, if you need to leave the room, it's okay. So we know what the terminology of the Second Amendment is, and then if you go to the founding period, the words meant exactly what they said, like arms and militia. The first Militia Act, 1792, passed by the United States Congress. It required every able-bodied white male in a certain age group, to provide their own arms and to sign up for militia duty and to muster when in order to do so. The word white was crossed out during Reconstruction in 1867. And what did you have to provide? You had to have a musket, which was a military grade weapon. You had to have a bayonet. A bayonet is like a high capacity weapon because you can stab people without limit, without ever having to reload. You never give out ammunition with a bayonet. Or you had to have a rifle, which was more of a sniper weapon at the time, and more of a sharpshooter's gun. Or if you rode a horse, then you had to have two pistols. So those were the arms, those were the military grade arms, but they were the same arms that people in that society had for hunting, for self-protection. They did a lot of shooting matches, so sport. And that's the way things stood basically until, as I said, in the 1960s, the propaganda was made up in polite intellectual circles, judges and lawyers in particular, that the Second Amendment only protected a collective militia right and not a right of the people. And that was so that any and all gun control laws could be upheld. If there's no Second Amendment right to individuals, then the sky's the limit in terms of the restrictions that you could enact. So finally, there were two basic jurisdictions that banned handguns nationwide. It was the District of Columbia and Morton Grove, Illinois. Finally, Chicago got around to banning handguns as well, and several other Chicagoland localities. And so the Heller case comes along and challenges that. And lo and behold, when the case got to the DC Circuit invalidated the ban. DC was horrified, and they thought, well, this should not happen to us, we're special. And so they decided to file a cert petition with the U.S. Supreme Court. And mind you, they were urged not to do that by their anti-gun colleagues from states like New York and California and other places. Like, don't go to the Supreme Court. What if they uphold the DC Circuit? That's exactly what they did. But nobody knew what was going to happen. It was kind of like Russian roulette on both sides. Nobody knew how Justice Kennedy was going to vote, for example. And I was in an oral argument that day, and having filed an amicus brief on behalf of a majority of members of the U.S. Congress. And so the first time Justice Kennedy spoke, his mouth slowly opened and time stood still because nobody knew what he's going to say. Because you always figure you can try to gauge where a justice is going to go by the questions they ask. And he asked the attorney for the District of Columbia, Walt Dellinger, well, weren't the settlers people who needed to have guns to protect themselves from criminals and Indians and grizzly bears? So never mind, there were no grizzly bears east of the Mississippi. What did that indicate about his thought? Obviously, he intended the Second Amendment to mean as an individual right. And so people in favor of the DC ban, their hearts sunk when he asked that question. Because we figured, and our hearts were lifted. We figured that that our side would prevail. And the same thing happened on the last day of the session when the court announced the opinion. So our side had a big fright when the Chief Justice said that Justice Stevens will announce the opinion in before he could say the name of the case. You think, Justice Stevens, oh crap, that means we lost. And it turned out to be some totally innocuous case. But when he said, Justice Scalia will announce the opinion in District of Columbia versus Heller, and we knew we had won, and the other side knew the game was all over. So part of our discussion today about the AR-15, by the way, nobody's taking names. How many of you have an AR-15? I'm hoping if you don't have one, you don't have one, you need one. Okay. And in fact, I don't know whether any of you were lawyers about 10 days ago, because that was right before the vote in the Senate committee in Virginia. When it looked like they were headed toward a ban, but the ban that was not to be, at least for now. So the interesting part about the Heller case was the test that Justice Scalia formulated for what arms are protected by the Second Amendment. It was basically the kinds of arms that are commonly possessed by law-abiding people for lawful purposes. Very simple. And handguns were obviously within the contours of that formulation. So Justice Scalia had a number of other really important parts of the opinion. We don't have time to go into all of that, but he said this is a no-brainer. We don't have to have a level of scrutiny or some kind of judicial test for how we decide whether a violation of the right to keep and bear arms is a violation of the right to keep and bear arms. If it's a violation, this law is invalid. Justice Breyer wrote a dissenting opinion saying that, well, the legislature needs to balance this way and balance that way, and they always balance it in one way. Imagine saying that in a First Amendment case about free speech. And then you get around to Justice Stevens' dissent, and he said, well, you have a right to bear arms in the militia, and that's all. So that wasn't going anywhere. So the district spokespeople went out in front of the Supreme Court when the decision was handed down and talked about how much harder they were going to make it on gun owners than even before. And they said, well, of course, the decision is incorrect. The Supreme Court just got it wrong. And so they did a couple of things. They made it more difficult to register guns in the district than ever before, because you had to register all guns. And then they banned what they should have called America's favorite rifle, because I'm not using the term they used, because I'm sick of that term, because it's meaningless and it's their propaganda, not ours. So we thought, hey, this could be a really easy litigation to bring. We brought a case, came to be known as Heller 2, and we challenged this new ban, mostly on rifles, because the Supreme Court had just said that the kind of arms that are protected are the ones commonly possessed by lawful people for lawful purposes. So we got production figures for the AR-15, and it was, at that point, I think a conservative estimate might have been about 4 million, I'm not really sure. Now it's probably 6 million or 7, I don't know, nobody really knows. But it's the most popular rifle in the United States today. So we thought, well, surely, it's a no-brainer. The court said commonly possessed arms are protected, this is commonly possessed. What else do we have to show? So our district judge said, well, the police said this is an extraordinarily dangerous weapon. And they said about the magazine ban that, if you have to reload after 10 rounds are used up, then that gives police officers a more chance to get the bad guy. That was a superficial opinion, but we argued, well, it's a fundamental right, and fundamental rights in our jurisprudence get top priority. You use strict scrutiny to look at any gun ban or any ban of any type, and that's the standard of judicial review. And the court had even in Heller used the term fundamental right twice. And our district judge said, well, they didn't use the word fundamental right enough. That's only twice. And so I'm not going to consider this a fundamental right, and I'm going to uphold everything that the DC did, based solely on the city council's findings that these guns are so horrible and dangerous. So we go up to the DC circuit, and we thought, surely we'll win there because of the Supreme Court's formulation. And lo and behold, that court said, yeah, they're commonly possessed by law-abiding people for lawful purposes. We meet that. Nonetheless, there's always a catch. We're going to apply what they call intermediate scrutiny, and they're going to say, well, somebody in the council hearing, yeah, it was a Brady Center lobbyist, said the purpose of a protruding pistol grip is to spray fire and kill as many people as quickly as possible. So a lobbyist said that. We had evidence from national experts and Army or military experts that the purpose of the pistol grip was simply the design of the rifle. It's got a straight line stock. So you know the vocabulary. It's a straight line stock. It comes straight back, so you have to have the pistol grip. If you had to grip it like that would be exceedingly uncomfortable. And you want to have comfort when you shoot a rifle because you want to hit the target. And so that wasn't good enough. We had sworn evidence in the case about the purpose of a pistol grip and the other features that were banned. And that was not good enough because the judge did this balancing test. It was Judge Doug Ginsburg. And he, a 2-to-1 opinion, upheld the ban. So we did get a dissenting opinion. And we might have to guess who the dissenting judge was. Common use, law-abiding citizens, lawful purposes, self-defense, hunting, sporting use, target shooting. We should win. Like at that time, Judge Kavanaugh was not that well known, and so for my own part, I kind of forgot about him until the spring of 2 years ago, was it? And I wrote a law review article about why our side should have won, and that's what you do when you lose a case. How many of you are lawyers, by the way? Is anybody here, you ever done that? You lose a case, you should have won. Go write a law review article. That'll show them. So anyway, when Judge Kavanaugh got the nomination, that was just a super day. And we don't have the court hasn't accepted the case at this point on this issue on America's favorite rifle, but hopefully they will. So then came along, the day that Heller was decided, it was already, all the complaints were drafted to file against Chicago and the other Chicagoland jurisdictions that had handgun bans. And so, there were two major sets of litigants, the McDonald group and the NRA group, and cases were litigated. A lot of the local jurisdictions repealed their ordinances because they didn't want to have to pay the legal fees to defend them. And everybody figured the handwriting was on the wall anyway. With Heller decided, it looked like the Second Amendment was going to be held to apply against the states and localities through the 14th Amendment. That's exactly what the court did in the McDonald decision. Part of that analysis was the 14th Amendment was adopted primarily to do away with the black codes. These were reenactments of the slave codes, and these provisions said that imposed all kinds of legal disabilities upon African Americans, even those in the antebellum period who were free blacks and who were not slaves. And the one important for our purposes was to carry a gun, you had to get permission of some kind of authority. The very first example of a black code provision that the McDonald case mentions, the 14th Amendment meant to do away with, was a Mississippi state ordinance or law providing that African Americans had to get permission from the authorities in order to carry a gun. That's kind of significant that they picked that particular law because that's about carrying guns. And that's going to get into Amy's topic about the right to bear arms. But it's interesting that the maybe issue states that we have, the ones who do not have shall issue, is exactly the same thing as that black code provision. You have to get the permission of the authorities, and they decide what the criteria is, whether they think you need to carry a gun. It's not enough that the Second Amendment refers to the right to bear arms. So the McDonald case went on to do another thing I thought was really tickled me. Remember the judge who said Heller only mentioned it's a fundamental right twice? Well, if you do a word search on fundamental right in the McDonald case, it's at least a dozen times they said. And it's almost like the court was saying, have we said it enough now that it's a fundamental right? So that did away with the Chicago and the other handgun bans in that period. And then we started having no more action by the Supreme Court. It was like Mark Twain said, the reports of my demise have been greatly exaggerated. Well, all of a sudden, lo and behold, the Supreme Court rendered an opinion. Justice Scalia had died by then. There were only 8 members of the court. It's called Catano versus Massachusetts. And in that case, the court sent back to the Massachusetts High Court their upholding of the stun gun ban in that state. The Supreme Court said, you got it wrong. We had 3 tests that we provided about one of them, for example, that the descendants of the guns that were available at the founding are the kinds of arms that are protected today. And so that, for the most part, that means rifles, pistols, and shotguns, but it also meant that just because it's a newly invented weapon doesn't mean it's not protected, which stun guns obviously didn't exist at the founding, but they met the test of not so much common use, because there weren't anywhere near as many of those as guns, but common enough. And the neat part about that case is that the stun gun was possessed in a parking lot of a supermarket. The Supreme Court could have just said, well, there's no right to take a gun outside the home, and therefore we're not going to hear this case. But they assumed that you can take an arm under the Second Amendment outside the home, which should be a no-brainer, but for those who are fighting the challenges to their may-issue carry regimes, don't like the idea that the Supreme Court assumed in that case that you can take it out of the home. So to that extent, it was a victory for our side. But the court has turned down other cases up until recently. And one of them was an ordinance from Highland Park, Illinois, which banned America's favorite rifle. Wouldn't that be cool if you could push a button and these statutes that use that term that I'm not gonna use, and you could make it the language of their statutes saying, America's favorite rifle is defined as, and then go on to list the characteristics. Then the other part you would want to do is to mandate that you have one, not that you go to the penitentiary if you have one. So I want to talk about these characteristics that are banned some. And before I do that, though, there was some further litigation in the circuit courts. I mentioned the Highland Park case. The Supreme Court denied cert in that case where they banned America's favorite rifle. And Justice Thomas wrote a dissent from that denial of certiorari. Justice Scalia was still alive then, he joined in with that dissent. Basically, Justice Thomas said that this is America's favorite rifle. I think he might have even used a term like that in there, in the dissent. And talked about the millions upon millions of rifles that are there, and that are in hands of lawful civilians in this country. There's been some other cases where there's dissents from denial of certiorari on other issues, like the Peruta case out of the Ninth Circuit upholding discretionary license issuance for concealed weapon licenses. Thomas wrote a dissent from that and joined by Justice Gorsuch. So, and now we have one case pending in the court. The same litigant, by the way, who challenged the ban on America's favorite rifle in the state of New York. It's a case called New York State Rifle and Pistol Association versus Cuomo. And in that case, the Second Circuit Court of Appeals upheld the ban. And what's curious about that case and the other ones that have upheld these bans, they don't say anything about the characteristics of the guns that are banned. It's probably because they don't know what they're talking about. They don't know the subject. They probably wouldn't know a muzzle brake from I know they wouldn't know a muzzle brake from a flash suppressor. These are judges, they're not educated in terms like that, and you have, they're from cultures where they're not around guns. The only thing they know about guns is what they saw in the movies. So, when you have that kind of culture that judges are growing up in, and the political operatives who help make them judges, they feel the same way. It's hard to have an intelligent discussion about the characteristics and how can you justify banning these different characteristics. So, so the Second Circuit renders this, 60-page opinion with less than one paragraph discussing the characteristics that are banned. And so how can you justify banning these characteristics? You would think that would be a hot topic for a judicial decision is upholding a law being challenged as unconstitutional, but not. But what they did do is about 85 times in the opinion used the propaganda term, the AW term. So instead of talking about what's being banned, they just keep using that in every other sentence, it seems like. And that's their way of persuasion. This shows what great jurisprudence we have as judges, that we can use that term over and over and over without end. And we can avoid the subject at issue, what's actually being banned. And then that gets upheld. There was no cert petition filed after that decision, by the way, because Justice Scalia had died, and it looked like at that point it was a 4-4 divide at the court, and new justice had not been appointed yet, and so no point in filing a cert petition, particularly if it might make that law. Now, this same New York State Rifle and Pistol Association filed another lawsuit on another subject, and that was New York City banned taking your gun out of your home. So in New York, you can get a carry permit only if you're somebody really special. Like the application says that commoners need not apply and deplorables really need not apply. You're not gonna get a carry permit unless you're really, contribute to the right people or do the right bribes. But you can get a premises permit. It might take 6 months, and you might have to pay $800. But what the heck, it's only a right that's in the Bill of Rights. So, but if you get a premises permit in the city of New York, you cannot take the gun out of the home. So a lawsuit was filed, and one plaintiff said, well, I want to take it upstate to my upstate second home. And another one said, I'm going to take it to a shooting range or a shooting match. But there was an affidavit filed by a retired police officer, saying that this would be in danger of public safety if you allow people to take locked up, inaccessible, unloaded guns in their car trunk from their home in the city to some other location. And the Second Circuit said, yeah, that makes sense. Like, here you have the right to bear arms in the Constitution, and here you have some ex-cop saying that this was in danger of public safety. Whoa, that's good enough for me, said the judges. So they upheld that, and you probably know the story since then. The city tried to weasel out of that and try to make the case go moot. Argument was held in the Supreme Court on December 2nd, and most of the argument was about moot. So the antis really want that topic to go away. They do not want the Supreme Court to decide any Second Amendment case, because not only would they invalidate a law like that, but they would also give guidance for other cases and give further guidance for how you determine these gun bans or these other restrictions that are so onerous. So now I want to talk about characteristics. I guess I could ask one more question. How many of you have put together a kit, like an AR kit? Well, they're really fun. I highly encourage it. But anyway, what are the features of these rifles that are so harmful and dangerous to society? And my favorite one has always been the pistol grip that protrudes conspicuously beneath the action of the weapon. And again, if there's any faint-hearted people, you better leave now, because we're going to talk about other features that are extremely scary. So back before Heller, we litigated cases challenging that definition as vague and ambiguous, violation of due process. A pistol grip that protrudes conspicuously. Like, anybody want to define conspicuously in terms of angles or inches? Like, what if they banned, instead of shotguns with a barrel less than 18 inches, shotguns with a barrel that's conspicuously short? And it's really an eye of the beholder, and it's comparative, because if you had a gun barrel only that long, one that was 15 inches would not be conspicuously short. It's the same token. If you had a pistol grip, like maybe a normal one would be 4.5 inches maybe. What if you had one that was like 3 feet, a pistol grip? So maybe you got a big hand, you need a long pistol grip. So that would make the short one inconspicuous. But by and large, these arguments that we made fell on deaf ears in courts, because they're clueless what that would mean, and what the heck, it doesn't matter anyway. It's just a gun restriction. The Second Amendment doesn't mean much. So, the judges would get laughed at cocktail parties with their friends if they invalidated a gun ban. So, why not? My favorite definition, actually, California tries to define a conspicuously protruding pistol grip. And it's one in which the web of the hand is even with or beneath the top of the trigger when the gun is held. So that's a part of the Second Amendment you didn't know about. The right to keep and bear arms except for those in which the web of the hand is below the top of the trigger when firing. So how frivolous can you get? to say that something's not protected because of where the web of the hand is when you're holding the rifle. I mean, what an argument. And yet, the Ninth Circuit has continued to uphold the California bans, and other courts have. I think my second favorite ban characteristic is the telescoping stock. So, what's the reason for banning those? I guess it looks scary because it's a tube instead of a wooden stock that's kind of flat, but the reason they give for upholding that is that it makes it concealable. So let's talk about, I mean, you might have an adjustment of 2 inches, maybe 3 at the most. The reason for it obviously is to make it adjust to your physique so that you've got a comfortable fit. You don't want an uncomfortable fit because you want to be able to shoot to hit what you're aiming at. So, so we've used we've made the argument in court, like, okay, what if at its shortest length, it would be a shoulder stock that was 4 feet long? Nothing concealable about that. You know, the stock this long and then all the rest of the barrel. But the judges' minds are so tiny they can't understand the fact that for example, you could set an overall length limit. It might be 26 inches. Some laws are like that on a rifle. No rifles that are under 26 inches overall length. Whether it has a telescoping stock or not, if it's at its shortest. But there's been just some kind of incredible inability to conceive of that argument, which is so obvious. The folding stock is another one that's banned as a characteristic. And by the way, sometimes they talk about, well, these are semi-automatic and they're so dangerous and they shoot as fast as machine guns, and there's no, in fact, some courts say there's no difference. The Fourth Circuit upholding Maryland's ban, there's no real difference between a full auto and a semi-auto. I mean, how incredible is that? But none of these laws ban the rifles because they're semi-auto. It's because they have 1 or 2 other characteristics. If it's a rifle, if it's semi-auto, if it has the detachable magazine capacity to accept the detachable magazine, then you look for 1 or 2 other characteristics, and that's when you go to the list. So far, they haven't banned any rifles just because they're semi-auto. So to justify these bans, you've got to ask, what is it about this characteristic that makes it so bannable? And that's where, as I said, the courts never address that in their opinions. One California judge recently held a case called RUPP, R-U-P-P,